So I am going to do my YouTube. Oh, hi, I'm Mike Podesta, by the way, and I'm doing my YouTube on PPM, PPOs, and due diligence. So, what is a private placement memorandum? First of all, so a PPM, private placement memorandum, refers to an offering circular for shares in a private placement. No particular form is prescribed. The idea is to disclose enough information to intrigue investors into performing due diligence and investing. So your PPM is meant to help prospective investors make prudent decisions. Your role as a member of the private transaction community is to present the transaction as transparently as possible and honest as possible. In other words, a PPM is a document whose primary purpose is to give the entrepreneur the opportunity to present all potential risks to the investor, usually a venture capitalist. Having a PPM protects the entrepreneur like an insurance would. In case this investment idea goes bad, he has already stated all possible negatives in the PPM and cannot be held liable for any losses. Another definition of a PPM is that a PPM is basically a prospectus for shares in a private company, much like the sort received by an investor in a stock, mutual fund, or other publicly traded security. It details all the terms of the investment, requirements of the investor, and proper disclaimers and disclosures related to business and the equity. So according to ppm.net, a private placement memorandum is most commonly used for companies seeking capital. Along with a business plan, a private placement memorandum is arguably the second most important document for entrepreneurs. Aside from the business plan, a private placement memorandum is vital to raising capital, both from the standpoint of professionalism and the need to protect oneself. So what are the private placement offerings and regulations? So a private placement offering, according to entrepreneurship.org, generally means the type of shares issued by a small or growing company to raise capital. An interesting fact about a PPO is that they do not go through the detailed paperwork and expenses associated with registering with the Securities and Exchange Commissions due to its meeting of legal exemptions. It also enables a company to structure a more complex and confidential transaction, since those to whom it is offered are typically a small number of sophisticated investors. In addition, a private placement permits more rapid penetration into the capital markets that would a public offering of securities requiring registration with the SEC. However, there are still some rules and regulations in place when it comes to selling of a private placement. It is important to understand the basic procedural steps that must be taken before pursuing a PPO. Different rules and regulations are set in place for different companies based on the size of their investments, whether they are $1 million, $5 million, or an unlimited dollar amount. Through Regulation D, one can procure equity financing through a limited offer and sale of the company's stocks or securities without registration under the Federal Securities Act of 1933. So Regulation D in the Securities Act of 1933 basically prohibits the general solicitation or advertising to promote the offering, sale only to accredited investors, and restrictions on the sales of securities. So although Regulation D is the most common exemption, there are still others. Section 4.2, according to the entrepreneurship.org, allows an exemption from registration for transaction or transactions by an issuer not involving a public offering. The offering should be made directly to prospective investors without the use of any general advertising or solicitation. When relying on the exemption under Section 4.2, the company must structure the offering in accordance with the following guidelines. The number of offerees should be kept as small as possible. 2. The offering should be limited to insiders or sophisticated investors who have a pre-existing relationship with your company. And 3. The prospective investor should be provided with at least a set of recent financial statements, a list of critical risk factors, and an open initiation to inspect the company's facilities and records. So Section 3A.11 allows an exemption from registration for any security which is part of an issue offered and sold only to persons resident within a single state by an issuer which is a resident and doing business within such state. So as with any rules and regulations, there are some kind of loopholes that they talk about that I'm not going to go too much into. But it is pretty interesting. So, next is, what is due diligence? I know I stated it previously that the investors need to do their due diligence after seeing the PPM. So due diligence, as stated previously, when writing a PPM, the idea is to disclose enough information to intrigue investors into performing due diligence and investing. So what is due diligence? According to Wikipedia, due diligence is an investigation of a business or person prior to signing a contract or act with a certain standard of care. That is why it's important to have a PPM. By presenting a PPM, one gives the investor the opportunity to do his due diligence by viewing the document, showing him or her all possible risks of investing. Due diligence can be conducted for many reasons, including the following. Confirmation that the business is what it appears to be. 2, identifying potential deal killer defects in the target and avoid a bad business transaction. 3, gain information that will be useful for valuing assets, defining representations and warranties, and or negotiating price concessions. And 4, verification that the transaction complies with the investment or acquisition criteria. So Christine Comfort, author for Bloomberg Business, breaks down the financial due diligence into 3 key areas. The first is an explanation of how you plan to use the funds. The second is an explanation of your business model and budgets. And the third is a legal review. So she states that basically it is essential to be able to provide a realistic assessment of your business, clearly articulate the reason for the financing, and explain for what exactly the dollars will be used. So use of the proceeds is where many deals fall apart. She then goes on to provide a checklist of those 3 key areas, which can be viewed in Christine Comfort's article titled "Preparing for Financial Due Diligence." So check that out if you want some more information on that. Next is what are term sheets and term sheet negotiations. So Tom Tolley, author of Bloomberg Business article, How to Negotiate a Term Sheet Part 1, defines a term sheet as a document prepared by a venture capitalist that sets forth the key terms of a proposed investment. So he mentions that a key mistake of many venture capitalists when writing up a term sheet is that they focus too heavily on the overall valuation of the transaction. That is extremely important to have an attorney negotiate a term sheet with you so that you don't have these problems. A term sheet is only a conditional offer, and the venture capitalist will perform further due diligence and negotiate key contracts such as employee agreements, the option plan, registration rights, shareholder agreements, and so on before the deal is even completed. So some key things that venture capitalists are looking for when writing their term sheet is definitely going to be preferred stock, liquidation preferences, dividends, reverse vesting, and drag-along rights, just to name a few. How are these things relevant, one may ask? Venture capitalists prefer preferred stock to founders' shares. This is because preferred stock provides certain protections such as liquidation preferences and voting rights. Liquidation preferences need to be negotiated because the venture capitalists would like to know that if something bad happens to the company, they will be the first to get their investment back. Dividends are also important to venture capitalists because this is an annual return on the preferred stock. One should try to negotiate a clause that makes the dividends non-cumulative. A reverse vesting is also important because venture capitalists want to make sure that their founders stay around. With reverse vesting, the founders set aside their common shares and then earn them over time. The standard is 4 years for that. So lastly, drag-along rights. This means that the minority shareholders must agree to a sale or liquidation of a company. In other words, the founders are basically left with nothing due to their failure in the company. This is oftentimes harder to negotiate than other areas. They say that it's probably best to focus on the liquidation and stuff like that before trying to go for that and spend too much time on that. So, as you can kind of see, the PPM, PPO, due diligence, they all kind of work together. It is the investor's responsibility to do their due diligence and create a term sheet, and it is the entrepreneur's obligation to create the PPM, private placement memorandum, and as well as the offering. So they're all used together, and they're all vital and very important when venturing out and doing something like this. So hope everyone learned a little thing or two, and I hope everyone has an awesome rest of the day. See you in class soon. Bye-bye.